All right, let's get started. Welcome, good morning, good afternoon, and good evening to everyone joining us from around the world. I am Anasuya Shyam. I am the Human Rights and Trade Policy Advisor at the Human Trafficking Legal Center. We are a nonprofit based in Washington, D.C., and we engage in both strategic litigation and non-judicial remedies like the Tariff Act to combat forced labor, among our other areas of work. Before I introduce the topic and our wonderful lineup of speakers, I want to mention a few quick housekeeping matters. This webinar is being recorded and will be sent to all attendees as well as those who registered. To those speaking today, please remember to mute yourselves when not presenting. We will hold questions for the end, hopefully the last 30 minutes of this webinar. So during the presentations, if you do have questions, please feel free to post them in the Q&A box at the bottom of your screen. These can be addressed to a particular panelist or to the panel in general. And now on to the webinar topic. So welcome to our webinar discussion on using the Tariff Act to disrupt forced labor in supply chains, a practitioner's perspective. For those of you who are new to the topic, the United States and specifically US Customs and Border Protection has the authority to stop goods made with forced labor from crossing US borders and reaching US markets. This authority is granted by a 90-year-old statute called the US Tariff Act, which prohibits the importation of goods mined, manufactured, or produced wholly or in part by forced labor, forced child labor, and prison labor. So recently, you may all have come across the flurry of activity around the statute, with many NGOs filing petitions under the Tariff Act, making allegations of forced labor, and CBP issuing detention orders or withhold release orders. In the last 2 years alone, CBP issued over 22 withhold release orders or detention orders prohibiting goods from entering the US market. These have covered a range of goods, including tobacco, tomatoes, cotton, diamonds, computer parts, and seafood, to name a few. This increase in enforcement is having an impact. Corporations have begun to take note of increased legal, financial, and reputational risks for forced labor in their supply chains, including the risk of accruing monetary penalties for forced labor. Discussions have emerged in other countries on the efficacy of a Tariff Act-like prohibition. In fact, Canada has already implemented such a prohibition, and there are debates in Australia to introduce similar import controls, at least in the Xinjiang context. It is in this backdrop, amidst rising attention to the Tariff Act, that we are having today's topical discussion with our amazing lineup of panelists who've all had firsthand experience with the Tariff Act process. Just a quick caveat, today's presentation will focus on the NGO perspectives and experience submitting petitions under the Tariff Act, responses from corporations, and the impact of the process in general, including recommendations for improvement. If you'd like to learn more about how to submit a petition, please go to our website at htlegalcenter.org and look for our practice guide on the Tariff Act, available in multiple languages. So without further ado, I want to introduce our first panelist for today. Our first panelist is Duncan Jepson. He is the founder and managing director of Liberty Shared, a leading global anti-trafficking NGO working to counter modern slavery and wildlife trafficking. Welcome, Duncan, and the floor is yours.
Oh, thank you very much. And thanks very much to the Human Trafficking Legal Center for inviting me. We're going to allot ourselves 10 minutes or so to talk, so I will quickly get into it. Whilst I share something, I'll say the relevant bits to my own history in relation to this are the one in the 90s. Before I became a lawyer, I managed and built supply chains from China to the UK. It was about 7 years of my life running a business doing that, from about 93 to about 99. And then I became a lawyer, worked in corporate finance, was in Asia, and became a regional general counsel of the ING investment business, and then BNY Mellon, and essentially was a defendant. Ran litigation largely because we would get prosecuted, or from a regulatory perspective, across 14 different countries. At any one time, we would have probably between 20 or 30 forms of either complaints or litigation that we were involved in. So that was my background, and I came to this with the idea, I mean, to be honest, in short, to just sort of turn it around and see what could be done on the other side of the fence and on the corporate accountability side. And I liked, 307 and the idea of a WRO or a finding a lot, because it offers what for me is a kind of Goldilocks area of corporate accountability. Because it's obviously in the US, you have the downside to it as denial of entry into the US market, which obviously has a profit and loss impact, but it also ultimately has a future earnings and balance sheet impact, which is what investors are going to look at. So if the WRO, in 307 had existed, and I pick a country, arbitrarily, say Portugal, this would probably not be a conversation that I would be having, and it would be probably of much less interest, and wouldn't have tried it. For me, it was something that once I learned about it, I would say 3 or so years ago, we signed, I think, as others have, an MOU with CBP to really get to understand what CBP could do with the information, how we could use it, and that opened up some possibilities. What I particularly like from a sort of action perspective is that you obviously are submitting a petition with evidence to really form an argument that doesn't have to go through a court and doesn't have to go through due process in that sense. Everything is between yourself and the investigator, and then obviously they then take it forward if they feel compelled to do so to their internal legal. This is a good mechanism, and I think it reduces the risk of A, failure, but B, obviously doesn't expose you to perhaps discovery if this was going to be a court action and you are in some way involved in attorneys pursuing a case in some jurisdiction. The other thing is that it's multi-jurisdictional if you're working on looking at a corporation that is either global or head office elsewhere. We've been involved, I guess, in a number of WROs at different stages. So we were actually in Malawi when the Malawi WRO was announced. We were working on a data gathering platform with a large NGO network there. And so we got to see firsthand the impact of the WRO kind of from the inside. And that was fascinating. And it helped us to understand what is needed to be included in the petition and in the subsequent work to ensure that remediation is very clear. One thing that was very unclear to the Malawians was, firstly, what is a WRO? What did it mean? And secondly, how on earth do you get it revoked? And it was fascinating to be part of that for, I guess, the best part of, 6 months to a year that we were involved. So I think, the fact that it's an administrative action, the fact that you can control what information you bring and what you put in the petition gives the NGO a lot of control. And it then brings the second point I'm putting on my slide, which is this strategic or is it tactical? And I think, when I've had conversations with others, their aim has been, let's get a petition in. And I think obviously that's a big step. For myself and for Liberty Shared, the question was strategically, what can you do with it? From being a corporate defendant, obviously what I always disliked was if we were held criminally liable, because the burden of proof, beyond all reasonable doubt, once you've been found criminally liable, or it's looking like you're opening the floodgates to all sorts of other action because they have lower standards of burden. And WRO is, in a way, the opposite. It's, you are looking because you're trying to convince them that it is really reasonable suspicion that forced labor in whole or in part of the production. And so that's an important element to it, is that it's low. In our research, which we did for both FGV and for Sime Darby, and we worked on with Malawi, and we did initially when we started, it was in the fishing industry, trying to hit evidentiary level that is beyond all reasonable doubt. But obviously, you're not necessarily going to get there, particularly in something as kind of dislocated as say the fishing industry. But therefore, you can look at it as a strategic resource for corporate accountability, providing you see it as really a ways to an end rather than necessarily an end in itself. It can be argued whether it's a means or a ways, but certainly I think of it as something that is powerful because it's a US agency. It denies access to the US market. It obviously raises other possibilities depending on what evidence you have with other US agencies, which are well resourced. do have authority and power themselves, and then that can apply a lot of pressure onto the corporation. Those of you who've bothered to follow the Sime Darby sort of journey, the day that WRO was released, I made a complaint to the Malaysian Stock Exchange about Sime Darby, and also to the Home Office under the Modern Slavery Act. And I think therefore you can build in these other steps. And what I'd also done is start speaking to the investor base in Southeast Asia, and I've had two panel calls with about 30 investment institutions, and I have another one tonight actually. And then on Tuesday night I spoke to the Exchange Commission in Malaysia about my complaint. So you start to build in a bit more meat to the strategy, putting pressure on the corporation. The other thing is that I've noticed, I was used to it certainly working in financial services. You are multiple jurisdictional, you are looking at the highest burden of compliance. I've noticed some of the conversations I've had, say on palm oil, is they've asked me about whether I was interested in the ILO conventions and treaties. I personally, not really in this case. If the corporation is bound by laws that may come from that, but ultimately they're bound by what I'm looking at is the highest burden that they should be obligated to, and have they reached that? And of course, the 307 and possibly the WRO are much higher burden than maybe there is in Malaysia, for example. Corporate accountability as strategy and objectives. I sort of talked a bit about that. One thing I want to mention here, before my time is up, is that I think the petition is really, for me, was the beginning. And so we were going to file a petition for FGV. ILRF and some of us and so forth filed one, and there's been the one filed before that. And so in conversation with CBP, we decided that it was pointless us filing a petition. We did have a huge amount of evidence and information, and we continued to gather that through 2019, 2020 into 21, and still keep providing information to CBP about these businesses that are already subject to WROs. And I think that's something that, two things, donors have to realize that funding an NGO to get to a petition is just inadequate. You've got to fund them all the way to the end of whatever the strategy is. But the petition is really the starting of the clock for CBP. If they don't have any further information provided in the petition, and if the petition is just desk-based, for example, then there's going to be a paucity of it. It isn't going to get across the line to a WRO, or it's going to take 18 months to 2 years. And you want to shorten that time down as possible. So these need to be funded properly. I've seen there's a couple of funding proposals that have been done. I personally have not thought they were adequate enough to do the job. The other side of it is risk management. Liberty Shared is a small NGO, and I actually shrunk it during last year to make it even smaller, because you're going to take on this risk. You want to be wary that you can't have lots of multiple programs going. One of the things that interested me was that we had a couple of donors who wanted to do corporate collaboration, and who were funding us. And the corporate collaboration didn't involve us because we don't do that sort of thing. But I had to ask them, how are you going to explain your convening collaborative industry things, and at the same time funding us to seek accountability? I actually stopped the funding for the accountability in one case because it just seemed inappropriate, and because clearly they thought that a collaborative and convening was the way to go. Having said that, now the WRO came out, and obviously the WRO and FGV came out in the Sime Darby. In the palm oil case, those collaborations and convenings don't make so much sense, because whose side are you really on? Now you're talking about real liability, particularly with the complaint to the stock exchange. Now you're looking a bit like you're trying to mitigate and defend the corporation rather than seek for them to change their behavior. And that's other part of it for me was, when I was on the other side as in part of a defense, to say that there are two sides. And if you've been working with the corporate and you've been paid by them, then it might be that you get dragged into their defense to write an affidavit or make some statements, particularly where there might be a regulatory issue, and statements are valuable. So the final bit for me is, having said all of that, I've been lucky to be teaching at the National Defense University this last year, and on strategy and strategic leadership, and we're always constantly discussing these two quotes. First one is a kind of Tyson plagiarizing von Moltke. everybody has a plan until they get punched in the mouth. And the second is eyes and has, plans are nothing and planning is everything. I think if you have a strategy that is trying to create corporate accountability, put pressure on corporations at a kind of multi-jurisdictional level to change their behavior and their practices, then you have to expect also that it isn't going to go to plan. And so as you're putting that in place, you should build into that some forms of flexibility that, and that might be financial resourcing, that might be different types and talents of people that you might need, but you need to be able to think, well, if it doesn't go quite as I wanted, and that may be that it goes better, then you need to be able to make the most of that at the time and be flexible. Sometimes when I've listened to people, I've thought, well, what happens if it doesn't go your way badly, but also well, have you got enough flexibility in that to make the most of that opportunity, because it won't come around again. So at this point, I'll finish here and pass it on, and I'm happy to take any questions at later on.
Thank you, Duncan, for your presentation and your remarks and your experience with the Tariff Act process and the impact. We look forward to your participation in the Q&A session. Just a reminder for all the attendees here, please do post your questions in the Q&A box and we will address them in the Q&A session. Our next speaker is Charity Ryerson. She is the founder and executive director of Corporate Accountability Lab, or CAL. CAL uses the creative potential of the law to develop new and underutilized legal tools for advocates and victims to hold multinational companies accountable for transnational human rights and environmental harms. Welcome, Charity, and over to you.
Great, thank you, Anasuya. Great to be here. Thanks to HTLC. I'd like to use my time to talk a little bit about two different petitions that Corporate Accountability Lab was involved in, and to try to use those petitions as an example of the differences in these kind of conditions of forced labor and how the Section 307 petitions could be used. So, I think Duncan got at this a little bit, but, the CBP clearly has a role here in protecting human rights, although the statute itself is fundamentally protectionist, right? It's written in a way that is designed to protect US businesses from unfair competition from incoming forced labor produced goods. That doesn't mean we can't use it for human rights purposes. It just means that it's not designed in a way to give remedy to victims or to address the situations that I think many of us as advocates are working on. So what I want to talk about a little bit is how we can use this tool for forced labor situations with all their variations, and think a little bit about how this tool can be used in a more nuanced way, or how it also has been used in a more nuanced way than folks might fully realize. So the two petitions I'm going to talk about, first, the Cocoa Petition. So back in February of 2020, international rights advocates and CAL filed a petition based on trafficked child labor in West Africa, focused on Cote d'Ivoire. Probably folks are familiar with this industry. It's kind of notorious for the trafficked child labor problem. There's a lot of kids being brought in from Mali and Burkina Faso to work on cocoa farms. These are smallholder, very small farms where these kids are working. This type of trafficking is really a result of extreme poverty. So that's kind of an important feature of it to think about as we think about kind of how this tool might be used in a situation like this. These farmers are producing for cooperatives or buying companies where the product is mixed. And so it's mixed at various levels along the supply chain. So it's very difficult to trace. But because of how widespread this child trafficking problem has been, it means that the whole industry is kind of tainted. So when we filed our petition, we looked at it from this idea of, what do you do with an entire industry that's tainted? So we named all the industry actors, well, not all, but most of the industry actors. And we asked for a slightly different remedy. So instead of saying we wanted an immediate WRO, we asked for a 6-month grace period during which CBP might take certain actions or request certain information from the companies. And I'll talk more about that in a minute. So then contrast that fact pattern, I guess, if you will, with the Xinjiang cotton petition. So this is a petition that HTLC and ILRF and the AFL-CIO, and I forget, there was 9 or 10 of us that were on this petition. This was filed, I think we did it in August of last year. For folks, probably, again, this is a really high profile situation. Both the Biden and the Trump administrations characterized the situation of the Uyghur Muslim religious minority in Xinjiang, China as genocide. There's hundreds of thousands of members of this religious minority that are in internment and re-education camps where they produce agricultural products, manufactured products for export. So this in some ways is like a very classic forced labor, it's a prison labor situation. And over the course of the past year, CBP has issued several WROs related to specific products and companies in the region. And 2 weeks ago, CBP banned all cotton and tomato products from the region. You know, this is a really big deal, and it's something that CBP should be proud of and should be celebrated. You know, there's not a lot of justification for bringing in products that are produced under these types of conditions. And in the end, when you have a large prison labor industry, it makes sense to just dry up the market for the goods. So insofar as there being a market indicates that there's that practice is going to continue, and drying up the market might suppress the practice, it's kind of a no-brainer. So we were really happy to see that WRO. There's also been a lot of seizing of shipments. So we've been really impressed with the way that the tool was used in this particular case. But so looking at these two different scenarios, what does that mean about the way that 307 petitions can be used? Seeing it as a pretty blunt tool, right? A pretty blunt tool that's not exactly made for what we're looking for as advocates. You know, I would say that we can still use it for a lot of different situations. And the way that we craft the remedy that we seek might have some impact on the way that CBP uses it. But we've also seen CBP do some things here where initially, I think as of 2 years ago, a lot has happened in the last 2 years in terms of the way that CBP enforces this statute. And so as of 2 years ago, I think that we all thought what they can do is essentially a WRO, right? They can kind of block goods from coming in. It's a little bit more complicated than that, but that was essentially sort of how we saw the scope of their power. I think since then we have seen in the Malaysian gloves case, in the cocoa case, in a lot of other cases, CBP taking different actions prior to and after issuing a WRO. And I think for us and for our purposes, this is maybe really where the action is. So comparing these cases, you know, with Xinjiang cotton, it's prison labor or internment camp labor. I think everybody knows that when prison labor is profitable, it creates a really perverse incentive for incarceration. This is just a recipe for a civil liberties violation. You know, as an aside, this is not just an issue with foreign prisons. I think certainly domestic prisons here in the United States that produce goods, it's the very similar dynamics are at work. I have personal experience with this. Several years ago, I spent 6 months in federal prison and worked in a factory and separated scrap metal and drove a forklift for 12 cents an hour. And all of those really problematic dynamics that certainly developed where I was as well. So I don't think that this is a foreign prison problem. This is a prison labor problem more broadly. But in that context, you know, it is obviously within CBP's mandate to issue a WRO like this, and the impact on the affected community, being the Uyghur Muslim minority, is most likely going to be positive, because if the Chinese government has less of an incentive to incarcerate so many people, then maybe they will incarcerate less. And so that's a good outcome. For ivory and cocoa, the picture is a lot more complicated. So if there was a countrywide WRO, it would block the importation of cocoa produced with forced labor, but it would also block the importation of cocoa that was not produced with forced labor. You can't tell the difference because it's all commingled at different levels of the supply chain. And we can't trace all the way down from the farm to a particular import because companies haven't released that granular level of data. So in response to our petition, CBP issued a 25-part questionnaire. We didn't get that from CBP. It was leaked from one of the companies that received it. But it sought information on audits and certifications and policies, and it sought farm level transparency. So to some extent, some companies had argued in the past that they couldn't provide farm level transparency. So even the request that they provide this information would force all of those companies to trace all the way down to the farm level. And that in and of itself is kind of a good outcome and a step in the right direction in terms of addressing these types of practices. I'll also say that over the past year, most of this since CBP issued that survey, most of the agribusiness exporters that kind of dominate the sector have begun to release data down to the cooperative or buying company level publicly. So if they release the farm level data to CBP, we don't have that, we don't know. But they did release some of this other data publicly, which does help trace it further. That tracing is so important because until we can connect those two dots, we're essentially only going to be able to say to CBP, look, it's your job to enforce the law. The law says that importation of goods produced with forced labor is against the law. So we have to ask for something that's really overbroad. I don't think that really helps farmers. It doesn't help businesses. It doesn't help CBP or the advocacy community. So I think that we have really a common interest. I think that if companies were willing to give that kind of farm level data, if we and our investigators on the ground were able to identify those specific instances of forced child labor on those farms, we could be notifying the company and filing petitions specific to those farms. And so CBP would be able to use this power in a much more surgical way that could have the kind of positive impact that I think that we're seeking to create for trafficked children. So, for future petitioners, if you're thinking about filing a petition and things that might be useful to consider, you're probably looking at this and saying, I'm going to give CBP all of this really sensitive information, and then are they going to use this in a way that is helpful or harmful to this affected community? That's a big concern that I think all of us have had. We've been very nervous about it from the beginning. Our experience in talking to CBP, folks have been much more open to engaging with civil society over the past year and a half or so. There's been real progress there. And it would make sense in a petition to ask CBP to do things besides issue a WRO. So does that mean ask CBP to require that the companies demonstrate that passports of migrant workers have been returned, or that to demonstrate that they comply with minimum wage laws, or that they're safe and sanitary housing conditions? Can you go through the ILO forced labor indicators and see if CBP can use the process of their investigation and determining if they need to issue a WRO to pressure companies to remediate the conditions that give rise to forced labor? I'm about out of time. So I guess in conclusion, I would just say that this tool can be rights promoting. And I think it really falls on CBP, the companies, and us as the advocacy community to ensure that it is.
Thank you, Charity, for that wonderful presentation and for all your work on the Tariff Act. Our next presenter is Esmeralda Lopez. She is the Legal and Policy Director at the now merged Global Labor Justice International Labor Rights Forum, or the GLJ-ILRF, where she works to advance workers' rights, combat forced labor, and ensure corporate accountability. Esmeralda, welcome to this webinar, and we're excited for your presentation.
Thank you, and thanks for the invitation. Can you go to the next slide? And thank you for helping me with the PowerPoint as well. Thank you. Global Labor Justice International Labor Rights Forum is a human rights organization that works to hold global corporations accountable for labor rights violations in their supply chains. We have been working to promote trade policies that respect workers' fundamental rights for decades. And we have also been advocating for improvements to the Tariff Act because we consider the Tariff Act to be a potentially valuable tool in our work. Next slide, please. So a little bit about our history, specifically in relation to the Tariff Act. In addition to advocating for improvements, we've also filed numerous Tariff Act petitions to protect victims of forced labor relating to Malaysia's palm oil industry, the cotton industry in Turkmenistan and Uzbekistan, South Asia's carpet sector, and the Ivory Coast's cocoa industry. Next slide. So why do we use the Tariff Act? For many years, my organization has made strategic use of various non-judicial complaint mechanisms to challenge labor rights abuses committed by both the government and corporations. For example, we've used things like complaint mechanisms contained in the US Generalized System of Preferences and the Organization for the Economic Cooperation and Development, or the OECD. We think that the Tariff Act can be a powerful incentive for corporations at home and abroad to clean up their supply chains and end the use of forced labor. Next slide, please. For the most recent example of a Tariff Act petition that we've worked on, I turn to the case of FGV Holdings. On August of 2019, my organization worked with partners to file a petition which highlighted some of the abuses and forced labor that was ongoing on the Felda/FGV plantations in Malaysia. We cited several field reports that were documenting cases of forced labor and human trafficking on FGV-owned palm oil plantations. FGV is one of Malaysia's largest palm oil companies and is a Procter & Gamble joint venture partner, and its largest supplier, which is important to mention for our purposes because it is a US-based company. palm oil. Just a little bit of information about palm oil. It's used in about 50% of all consumer goods, from lipstick to packaged goods to body lotions and biofuels. It's estimated that about half of the products on supermarket shelves contain palm oil. And this has had, the wide use of palm oil has had a really significant impact on the environment and workers. The petition was strategically filed with allies or co-petitioners, one of them being an environmentally focused NGO and other human rights organizations, because it was part of a longer running campaign to pressure this corporation specifically to act. For example, one of the partners, and Freedom United collected over 127,000 petition signatures from consumers around the world, urging CBP to issue a withhold release order and or what we would call a block on FGV palm oil. Next slide, please. CBP did in fact issue a WRO about a little over a year later, so last September of 2020. And we have been working with co-petitioners to ensure effective enforcement of WRO and remedies of the WRO and remedies for workers. So we've been meeting with members of Congress who have oversight abilities, specifically as it relates to the Tariff Act, to ensure that the remedies or the, if the WRO is to be lifted, that it only be done so when certain protocols or certain requirements are met. Next slide, please. And while enforcement of the Tariff Act has increased, there's still definitely challenges, and we mentioned them in the report that you can see the title of the report there in the photo. But we also discussed recommendations. Number one would be CBP should issue clear guidance and evidence standards. Because CBP has relied heavily on the public, like the folks on this panel, to file allegations, but has not issued any real adequate public guidance on its standards of enforcement and evidence standards. So we think that that's a recommendation that we support. Number two, CBP should increase transparency. CBP currently shares very limited information on enforcement. There's no publicly available information as it relates to specific detentions, re-exportations, exclusions, seizures of subject merchandise. Another recommendation would be to consult with petitioners prior to lifting any WROs. And that Congress should increase resources for enforcement of the Tariff Act and conduct increasing oversight. In closing, what I would like to say is that my organization advocates an approach to combating forced labor that promotes workers' ability to exercise their fundamental rights to organize and bargain collectively for better wages and working conditions. Broad enforcement of the Tariff Act is really only the first step to ending forced labor, we think. There needs to be binding agreements that include buyers, suppliers, and workers' organizations. And these agreements need to include transparent monitoring, grievance mechanisms, and protections from retaliation for workers, and which creates a binding accountability for failure to remediate. Thank you, and I look forward to questions.
Thanks, Esmeralda, for your presentation and for talking about ILRF's experience with the Tariff Act, including recommendations for improvement. Our final presenter, and we're very excited to welcome Andy Shen, who is the Senior Oceans Advisor in Greenpeace US and the US project lead for Greenpeace's Global Tuna Campaign. And he has been working tirelessly on forced labor and seafood supply chains and has considerable experience engaging with the Tariff Act. Welcome to this session, and the floor is yours.
Thank you, Anasuya, and great presentations, everyone. It's a pleasure to be here and to share about Greenpeace's work on the Tariff Act. I'm going to share my screen. And here we go. All right, so just to give you a little bit of history on Greenpeace's work on forced labor and fisheries. As an environmental organization, we work at the intersection of illegal, unreported, unregulated fishing, overfishing, and labor abuses at sea, especially in distant water fisheries, which is fishing that occurs in international waters or in the waters of other countries. And we do so because IUU fishing and overfishing are root causes of forced labor in fisheries. What we've seen and has been well documented now for some time is that overfishing of coastal fish populations has resulted in fishing vessels going further and further away at sea, chasing after fish. And that has resulted in an increase in operational costs. Of course, when fishing vessels are fishing far away, thousands of miles away from their home countries, it's going to increase their operational costs. And what happens is a lot of vessel owners see labor as fungible costs. And so therefore, they'll exploit workers, they'll cut corners, they'll use forced labor, and this will basically decrease their operational costs and allow them to continue fishing in an otherwise unprofitable environment. And forced labor is also a driver of overfishing and IUU fishing. When workers are being required to work 18 to 20 hours a day, every single day with no rest, this of course can result in depletion of fish populations. Greenpeace's work on forced labor in fisheries dates back to 2014. In 2015 to 2017, we ran a global campaign called Not Just Tuna, and this involved a campaign against the largest tuna company in the world, Thai Union, which is based in Thailand. And this resulted in a landmark agreement in 2017 that involves sweeping reforms, commitments from Thai Union involving not only environmental sustainability in their supply chains, but also labor rights protections for workers in their supply chains. And in 2019, we started our Beyond Seafood campaign, which is a global campaign involving our Southeast Asia office, our Taiwan office, and the US office. And what we do in this campaign is we're pressuring the Taiwanese government to improve human rights and environmental protection in their distant water fisheries. And also as part of that campaign, we're working on pressuring FCF, which is one of the largest tuna traders in the world based in Taiwan. That's actually also the parent company of the major US tuna brand Bumblebee, which many of you probably know, which holds a quarter of the canned tuna market in the US. And last year, we updated our sustainability, labor and human rights and chain of custody asks for retailers, brand owners, and seafood companies. So this suite of asks is comprehensive in that it covers both environmental and human rights concerns. And it covers the whole seafood supply chain, and it's specific and tailored to distant water fisheries and the unique conditions that workers face on the high seas. And we've been asking all the companies that we engage with, both from processors to retailers and buyers in the US to FCF, to adopt some of these strong commitments and to implement these processes in their supply chains. So our involvement in WROs dates back to the first ever WRO issued by CBP on a fishing vessel, which was in February 2019. And all of the 4 WROs so far on fishing vessels have been on Taiwanese owned or flagged, which means registered fishing vessels, tuna longliners, which are fishing vessels that use specific gear and fish on the high seas chasing tuna and account for some of the most horrific conditions for workers at sea. That Tunago 61 is notorious. It's been covered by numerous organizations, but was featured in a Greenpeace East Asia Misery at Sea report, where we, Greenpeace and allies, conducted jailhouse interviews with crew that detailed horrific accounts of abuse at the hands of the captain on the boat. There was another Taiwanese fishing vessel that was subject to WRO called the Yulong No. 2 in May of last year. And then the last 2 were in August and the New Year's Eve. And those were involving fishing vessels that were featured in the Greenpeace Southeast Asia report called Seabound, The Journey to Modern Slavery on the High Seas. And Dawang was actually a very notorious fishing vessel. It's actually a confirmed supplier of FCF in 2019, and therefore also likely that it supplied Bumblebee, since FCF supplies over 70% of canned tuna for Bumblebee in the US market. And of course, the process of getting a WRO is more than just us publishing a report. We also engaged with CBP behind the scenes, provided information and documentary evidence, including contracts in some instances that showed that the workers were subject to conditions, sometimes written in contract, that resulted in forced labor. So, as Duncan was saying, and Charity as well, and Esmeralda, the Tariff Act and pursuing the seizure or the ban and blocks of seafood imports is just one tool in the toolbox, and is one of many tactics that we use in our global strategy to shift governments, industry, and the public. So we, of course, are a campaigning organization. So we have been campaigning on FCF in Taiwan, Bumblebee, Walmart, and Costco here in the US. We engage with public. We have a lot of supporters, and we try to shift the mindset of consumers to to eat less and better seafood. And by better seafood, we mean more sustainably caught seafood and more ethically produced seafood. We also engage with the US government. Last year, we and allies in our coalition succeeded in getting Taiwan on the list of goods produced by forced labor for the first time. And this was the first time that Department of Labor put distant water fishing powers on its list of goods for forced labor harvested on the seafood harvested on the high seas. And we also engage in UN advocacy, do some rankings of regional canneries, retailers in the US, legislation, and potentially litigation as well. So what's the WRO impact on corporate behavior? Well, we've seen that, based on our conversations with some organizations that work with companies here in the US, that there has been a significant impact. Brands and retailers are affected by disruption in their seafood supply. They're concerned, they're upset, and this is something that they want to avoid. At the same time, WROs and corporate campaigns, we've been told, has been leading to an increase in some US buyers adopting a human rights due diligence approach to addressing human rights risks in their seafood supply chains. And of course, that's important because when we're talking about the seafood industry and the US buyers, right now, there are very few US buyers that are actually conducting human rights due diligence to the vessel level. Most of them stop at the processor level. And we've done research that's shown that many processors, especially in Southeast Asia, themselves are not conducting due diligence of their suppliers. So there's a lot of work to be done to ensure there's visibility and action being taken on fishing vessels in an industry where forced labor is systemic on the high seas, and there's high risk of forced labor seafood entering into the US. And so I'll close with some recommendations that we have based on our experience with the Tariff Act and also our engagement with CBP. And so first of all, CBP, for its enforcement of the Tariff Act on forced labor seafood, actually uses a very unique program that's administered by the US government agency called NOAA, which is responsible for oceans issues. And so NOAA, a few years ago, under the Obama administration, established what's called a Seafood Import Monitoring Program. So this program is actually designed for environmental purposes, and its purpose is to detect and block illegally caught seafood, illegally in the environmental sense, from entering into the US market. And so what it requires is that it requires importers to provide documentation tracing the catch of the fish from the fishing vessel all the way to the point of entry into the US commerce. And now currently the program only covers 13 species of seafood. And we've been advocating along with environmental and labor groups that this program be expanded to cover all species of seafood. So for example, the program currently doesn't cover squid. And as we know, recently there has been a lot of controversy in some distant water fleets where forced labor was used to catch squid. And so expanding the program to cover all species would mean that the CBP would then be able to have at its hands this data to be able to trace suspected forced labor caught fish to the point of entry in the US. We would also recommend that the US government, Congress, establish requirements for labor key data elements as a condition of import of seafood into the US. So currently, the import monitoring program only requires environmental data. So we would think that it would actually also be very powerful if certain labor data was required. For example, crew manifests, so that vessels are able to share, who exactly is working on the vessels. Verification that no recruitment fees or guaranteed deposits are being charged to workers, which is actually a very commonplace in the industry. Other data that could be required is proof that fishing vessels are not staying out at sea for more than 3 months at a time between return to port, because duration at sea is a significant risk indicator of forced labor and trafficking in the industry. We're also recommending that the US Congress establish a clear and convincing standard of proof for seafood harvested by vessels flagged to countries on the Department of Labor list of goods. So because forced labor is systemic in distant water fishing, there's a high risk that this seafood is entering into the US. And right now there is little oversight by US buyers in their supply chain at the vessel level. So that means that there's a significant risk right now that a lot of seafood entering into the US is produced with forced labor. And so we want to see that higher burden of proof being placed on importers so that they are required to conduct human rights due diligence and have complete coverage over all of their fishing vessels. And a few other recommendations include shifting from a case-by-case, vessel-by-vessel approach to enforcement, which is what CBP is doing now, to what they're now considering, which is a fleet-level, trader or processor-level approach to enforcement. And fleets, are oftentimes owned by individuals or fishing companies. And if one fishing vessel has problems, forced labor problems, or inadequate policies, then it's likely that all of the fishing vessels in that fleet have those problems as well. And traders and processors are choke points in the supply chain. So if the trader or processors themselves don't have adequate policies or processes and practices to ensure there's no forced labor in their supply chain, then it's important to target those corporate actors in the mid-tier of the supply chain and make sure that the seafood that they handle is not being sold in the US. And lastly, more transparency. Currently, importers and buyers that are subject to WROs, there's no visibility into who's being affected. And of course, as corporate campaigners, we want to see companies that are profiting from forced labor in the supply chain, that their identities be disclosed to the public. And that would obviously be a disincentive for them to continue to do so, and would drive change in the way that they handle their business. And lastly, Greenpeace and other allies that we work with on the Tariff Act are recommending a worker remediation fund. As Charity mentioned, currently the Tariff Act, it punishes the producer in the fishing industry, the fishing vessel, and it punishes the importer. But there is no guarantee that the workers that are exploited are being compensated or otherwise provide a remedy to bring them back to being whole. And so with the seizure of goods, with assets that CBP obtains through its enforcement of the Tariff Act, potentially it can establish a fund and make sure that that the workers are being adequately compensated, as part of the process of making them whole again. And I'll stop there, and I'm happy to answer any questions. Thank you.
Thank you, Andy, for your presentation. That was very insightful. And I think that can be a good segue into our discussion with other panelists. I know that there are a lot of Q&As already, but I want to take a couple of steps back and allow the panelists to kind of respond to some of the comments made by other panelists. And, maybe to think about the Tariff Act tool and the role it plays and the role that CBP has to facilitate trade, and viewing this as a trade statute, but also using it strategically in your campaigns to advance worker rights and eradicate forced labor in supply chains. How do you view this balance of CBP's role and the potential to maximize the impact of the Tariff Act? Duncan, do you want to go first?
Yeah, thank you. I mean, I just think you've got to be wary. I just see CBP as an institution that is created to control US borders and what comes through them. And it needs to, if it's going to, for me, if someone said, what can it improve? Number one is the data around what is coming through those borders and where is it from, so it can identify goods much more quickly under these WROs than it is currently able to. And that's about building more infrastructure. I think it's not a law enforcement agency. It doesn't have the power to get MLATs, I don't think, particularly easily. It can't get people on the ground. Is it going to be a valuable tool to be able to set out remediation with companies and explain to them what is required to lift the WRO? I mean, I just had a different view. I was, when I was general counsel and we had a dawn raid, the police arrived, they arrested people, took them away. They didn't hand us a letter saying, oops, you've got Abu Sayyaf's money that you're laundering. And then we said, oh, but we can't see down our tier 2 money suppliers because we don't do that kind of thing. You know, it was criminal, it's a money laundering issue. The fact that you can't see them is your fault. You have to go figure it out. You don't get to suddenly say, you know, I'm not prepared to spend the money on an intelligence team because I don't have to. I mean, there wasn't that excuse to have. There wasn't a ability to pull in a bunch of NGOs and have a discussion about terrorism financing and then say, go back to the regulator and say, look, we spent 3 days in a workshop. I think we're on our way to solving this problem. No, I think CBP has a role to play in the US. There's a US decision about not accepting these goods coming in. The better job it can do at identifying them and holding them or rejecting them, that's great. That it can set out in some ways to companies and to governments, the US society and people and government are not willing to accept these, that's great. But then we have to make sure that actually translates into a change in the system in that country. You know, I think that's what you're looking for, is you're looking for the local institutions, local investors, local business associations to then realize, well, what part do they play in this and what part do they need to, how do they need to get their act together, whether that's unions, businesses, government ministries, investors, banks, whatever it might be. And I think that's the onus goes back on them to say, if you want this part of your economy to function and have access to the US market, then you need to start building the kind of systems in your society that identify those problems and fix them to the level that CBP is willing to accept. And I think that's the bit that at the moment is a bit loose, is, as I think as everyone has said, is what is CBP willing to accept? But I'm not in favor of telling the company everything at all and saying, here's the things you should fix. They need to, if you're a business is not a natural phenomena, it's an intentional effort to take money, create risk, and then make profit. And if you choose to do that, then you choose to wear all of the risk that comes with it. And part of having CBP in this is to create risk for the business. And just being, you know, it's as an agency that does enforce this type of law, there should be a certain degree of distance so that corporations feel the pinch. I certainly, I'll just finish here and say that I always felt we got much further in corporations when one or two of the people in the corporation went to prison and suddenly everyone was awake. Why? What happened? What did everyone do wrong? You know, a business ethics, business responsibility things low down on the list of corporate liability, and that's the unfortunate thing. I think CBP, you know, has distance. It's aloof. That's what you want from a law enforcement type agency, as far as I'm concerned. But anyway, that's how I think about it.
Thanks, Duncan. Charity, Esmeralda, and Andy, I want to pose this to you. Do you think there are limitations to the Tariff Act insofar as ensuring advancement of worker rights and eradicating forced labor in supply chains? Now that we see that CBP has begun imposing monetary penalties, you know, to US importers, and there could be criminal prosecutions for forced labor on the horizon. Do you have any difference of opinion, or have you reflected on the Tariff Act and the role that CBP has?
Well, if I can jump in first, I mean, maybe first just responding a little bit to something that Duncan said, or sort of building on it. You know, I think that part of what makes this tool attractive is that it is kind of a strict liability regime, right? I mean, my own background as a litigator, we needed to show that whatever human rights violation we were going after, that the company at a minimum had knowledge, but often they needed to have purpose, intent. They needed to want to do this human rights violation. That is so hard to show, right? Developing that evidence is almost impossible. Whereas this statute allows you to say, look, it doesn't matter if they knew or not, it's just illegal to import it. So by using a trade law, that's just a big advantage, and it shifts the burden to the companies, who are in fact the best situated to make sure that their supply chains are clean. So I think from an incentives perspective, they're the ones who should be doing it, put the burden on them, and then perhaps they will. And so I think that that is just a structural advantage to using this kind of tool. But yeah, I mean, it does impose a lot of potential risks. I want to echo what Andy and Esmeralda laid out as recommendations. Those were all really great recommendations. And building on what Esmeralda said about retaliation, you know, this is, I think that when we think about how this could be harmful or helpful to workers and others, there are certain ways, certain things that could be built in here to this process through whatever way that's possible, but things that would be helpful beyond just even something that would be discouraging of retaliation. One problem that we've run into is security of our investigators. So, you know, insofar as it's the case that civil society, we're out there, we have investigators on the ground, they're doing this work, that are identifying instances of forced labor, that is really dangerous business, right? This is a particularly, any part of any economy that involves forced labor, there's a lot of other criminal activity going on there often. There's a lot of risk of violence, there's political retaliation in some contexts, and we haven't been able to get the kind of guarantees from CBP that our anonymous information that we provide them will remain anonymous. So we, in our own petition, our Cocoa petition, wound up having to give a much more limited set of data than what we actually had, because we couldn't get a level of guarantee on that we needed. And so I think if we're going to protect workers and we're going to protect investigators and we're going to make it possible for this information and evidence to be developed, we need a little bit more protection from CBP so that we can hand over that information and feel good about it and not feel like we're potentially walking into our own ethical violations or putting our partners at risk.
I would add that in addition to the things that Charity has mentioned, which I agree with, I think that as a labor rights organization, of course, we would like to see the remediation and the impact to workers before any WRO is lifted. I don't think that CBP is necessarily the agency that should be ensuring that, and nor do they have maybe the capacity or the knowledge in-house. I think that there's other US agencies that might be better suited. However, I think that while task forces, which require different US agencies to speak to each other, are a good thing, I think that until there's actual changes that might need to be legislative, that would require there to be kind of more due diligence in the enforcement of the Tariff Act as it relates to labor rights and what corporations must show. It might be difficult to really get something that is enforceable to happen outside of just information sharing within US agencies. But I think that ultimately, of course, the goal is to combat forced labor, but also ensure that the people impacted on the ground are actually seeing a benefit.
Andy, any thoughts on that?
I mean, Charity and Esmeralda covered a lot of it, you know, that I agree with. I think that there are obviously inherent limitations to the Tariff Act, but trying to be creative and you know, establishing different ways to provide remedy, pursuing more findings, more criminal prosecutions. And I think that ultimately as campaigners, we have to figure out how to use this as a tool paired with other tools. For example, when we use the Tariff Act, we know that in Taiwan, the government and the companies there are concerned. They're concerned about their access to the US market, and trying to use that and other ways to put pressure on governments and companies to act. But at the same time, you know, making sure that, you know, on the US side, is not just punishing the producers overseas, but making sure that the importers and the end buyers are held accountable as well, and pushing them for change. And whether or not that's CBP's sole responsibility, probably not, but definitely in, you know, in partnership with other US agencies and Congress, I think they can make that happen.
Thanks, Andy. I think that rounds out this particular discussion really well. And it is 4 o'clock, so time to open up our Q&A box and see the questions that we've received. But just before we delve into that, we received 1 or 2 questions before the webinar that I think I'm going to pose to you right now. The first question, and I think people have been thinking about this in different ways, is how do you assess if Tariff Act enforcement or WROs are appropriate? Because the workers themselves want to improve conditions, but maybe don't want to endanger their jobs through decreased markets for their employers. Anyone would like to go first? Duncan?
I mean, if you look at the case study of other industries that have had to redesign themselves because of a requirement to change their conduct, you know, then you obviously look to the efforts that have been made in the financial industry, healthcare, pharmaceutical industry. You know, then unfortunately there is this period where there is a lot of change. and jobs might be lost across the board. But, you know, for instance, in the finance industry, after the Patriot Act came out, yeah, jobs were lost, but huge numbers of jobs were gained on the control side of the business, compliance, risk, intelligence, all. There was a huge amount of hiring took place. But you know, that's the kind of thing that you think, well, okay, in these other agricultural, fishery, so forth, yeah, you might see these changes, and so there might be jobs in jeopardy because the pressure becomes quite a lot, and then it depends on the wisdom of the management to not do something crazy and just say, well, we're gonna, you know, just out of peevishness, do something drastic. And then I think it's about how you manage the fallout. Certainly, from the experience of speaking to, say, the Securities Commission in Malaysia about Sime Darby, you know, that's what Sime Darby is most worried about. CBP's action is something, but it's what concatenates from that, what's consequential you're looking for, that then makes people start to think a bit more reasonably, rather than you know, start pulling big levers to make big changes. So I think it depends on the strategy, what you've already started to do before the WRO hopefully comes out and what happens afterwards. But if you're sort of waiting for things to happen and then planning the next move and the next move, then yeah, you're very much in danger that the reaction might be egregious. And what happens is that people just close things down. For example, with Top Glove, you know, technically during pandemic, it became insolvent. And one of the things we were doing was speaking to a couple of NGOs, trying to get them to put in a claim so that to the administrator, the workers' claims actually came at the top of the priority with the administrator of the company. The company then came back to life because suddenly PPE was needed, but that hadn't been thought about. And that it hadn't been was a bit amazing, because it's always likely to be a problem that the company may crash if you're going to do that. So I think it's how you plan ahead, but you can't legislate for, some CEO deciding, what he's going to cash out and then close everything, and of course leave people completely stranded.
Thanks, Duncan. Charity?
Yeah, if I could just add something quickly, I guess, and maybe this doesn't really answer the question. It sort of emphasizes how complicated this analysis is. But a lot of industries that have a lot of forced labor are a little bit off the grid, which is to say the civil society organizations or unions are often not strong. And so if you're making a decision to do something which could impact this group of people and you're not making it with them, that raises a lot of ethical issues. And certainly from a human rights perspective, we have to be really careful to not just sort of come storming in like a bull in a china shop. So we've worked really closely with civil society organizations on our work here. And I think that is an essential piece, but there's no way that those organizations can be fully representative. So I think that it would be an ideal case would be where it's like a single factory. Maybe it's got a union that's strong and represents a lot of workers. You work with the union collaboratively to file the 307 petition. That if there is a union, then there's less likely to be forced labor. So there's just kind of a tension between the ideal, like achieving the ideal facts and there being a situation of forced labor. So I would just say it's a really delicate balance, and we think a lot about this issue, and it's hard.
Thank you. Does anyone else have any remarks, or shall I just jump into our Q&A box? We have around 10 to 12 questions. Any final thoughts on this?
Yeah, I can just share, we also work with Indonesian migrant worker trade unions in our investigations, my colleagues' investigations in Southeast Asia. And, a lot of times these workers that have been exploited, their number one wish is that they be fairly compensated, that they receive the wages that they are due. And that, a lot of times they're willing to even make their name public, knowing that there could be retaliation, because what they want is they want to see justice, and they want to receive what's due to them and their families. And that's why I think that's important to consider what is like the best wishes of those that are affected. Yeah.
Thanks, Andy. So I think now we will move to the questions in the Q&A box. The first question that I see is, how is the information in a 307 petition that's provided by an NGO verified by CBP, and how detailed should the information or the allegations against the corporation be so that it is able to take corrective and preventive measures?
I'll jump in and say that that's one of the recommendations that my organization has made, to have clearer guidance in terms of the evidence standards that are required for petitions. Right now, we are waiting, hope that CBP is supposed to issue regulations, has been due for those regulations have been due for a couple of years in terms of how petitions should be filed and more guidance on that. So I think that although and I'll let my fellow panelists answer this, although we might have some insight based on kind of informal conversations with CBP, I don't think that there's anything sufficient that is being made public as a kind of standard of evidence for what needs to be shared.
Thanks, Esmeralda. And just Joseph, for your information, we have tried, based on these informal discussions and the experience of petitioners, to list what we think is important to submit in a petition. It's available in our practice guide on using the Tariff Act, which can be found on our website. So thank you for answering that question. The next question is, the majority of WROs that have been issued have been on products from China. How much do you think US trade relations have an impact on the enforcement of the Tariff Act, and how can civil society groups navigate this? So the policy considerations at play here. Anyone wants to take a jab at this one?
I would say that, you know, policy and foreign policy always, I mean, not always, but it does definitely play a role in how some of these WROs are issued. Essentially, I mean, it is essentially the presidential administration empowers agency that they receive guidance from them. And so I think that that has influenced, especially recently with some of the WROs. How to use it to your advantage, I'll let someone else take that part. But I do think that we need to be aware of that. And I think that just as advocates, it's something to, as we have a new administration, to really think about how do we want to push the administration, in spite of it being a different one, to continue to enforce the WROs that were issued prior to them coming into office.
Does anyone else have a response, or should we move to the next question?
I mean, I guess I would just say that, you know, it does seem like it's obviously political on some level, right? And I think that there's, you know, there's reason for concern there. At the same time, if your agenda on one specific issue kind of overlaps for the wrong reasons with someone else's, I'm not sure that that's a reason to back away from it. So I guess I would say that I'm hopeful that just because there might have been some political interest in punishing China, and that coincided with like the Xinjiang cotton petition, for example, I'm still glad that we got that WRO. I think it was the right thing. I think that it's going to be a positive development for folks in those internment camps. And so I would say we use it if we got it. And the other sort of side of that is, what about all of these other industries that are not located in countries where it would be politically expedient to do them harm in some way? I hope that CBP can be politically neutral in that way. But I certainly recognize the political forces that give them more cover to do certain actions than others.
Duncan, I see that you've unmuted yourself.
Yeah, sorry. I mean, I think China and Xinjiang and the return of Great Pack competition made Xinjiang, you know, particularly after anyone who was around when the same things happened in Tibet. I mean, it was one that was there, and the petition was the right move. But they also did Malawi, not politically important at all. They did Malawi before Xinjiang. I know that there was a lot of thinking in the State Department and in CBP about whether a WRO against Malawi was a good idea, because of the amount of their US dollar came from obviously from the US, their foreign exchange. But it was probably still the right move, and certainly the people on the ground felt it was the right move ultimately. So far, I mean, you've got to get the sense that I think the politics are part of it, but there is also kind of a well-reasoned view about there are some places that need attention. And maybe if you take Malawi at one end and Xinjiang at the other end, you see some sort of logic in both of those cases. I was just going to say, to whether it was Joseph's point, and I know he and I were supposed to have a call at some point, but I think, you know, and to Charity's point, we work with a lot of NGOs on the ground, and risk management is crucial. I think one of the things that is pretty important is that you can't really be an NGO looking to do a petition if you have been paid by the company or by the industry to help them. That definitely creates a problem. And the one thing that I have heard, and certainly is one of the first defenses that a lot of these companies make to CBP is that they believe that it's a disgruntled NGO who's got an axe to grind and are looking for some sort of upside later on after the petition, like they want a consultancy or they want advisory. That is not a good way to go into this. If you are going to make a petition, then you are going to have to be independent for the rest of it. You can't make a petition and then decide you're going to short the market, or you're going to go seek a consultancy to solve the problem that you created. And that's something that companies seem to be wise to, which I think is an obvious thing. So I think the only thing you're putting a petition in, bear that in mind. You are definitely taking a side. And if you think that you've taken it and you then realize that your history is a bit more complicated than that, that might come back to bite you, because it will be a defense that they will raise against the petition.
Thank you to all the panelists for taking this question. Our next question is, are there any ongoing civil society initiatives to expand the Withhold Release Order authority to include other human rights abuses beyond forced labor? If anyone is aware of any initiatives?
Not to expand it to other human rights abuses, no.
Okay, thank you.
That'd be great, so let's do that.
Thank you, Duncan. I see that you've also unmuted yourself.
Yeah, I think some of us would like to see it include things like, environmental issues and wildlife trafficking, other things that are kind of in there. But I think that's a time away. Maybe this administration will be interested in that.
Thank you. The next question is, the information gathered from the questionnaire that CBP sent to chocolate companies could be very useful for NGOs and the public, as would other information CBP gathers. Any sense of CBP will be more forthcoming or cooperative with civil society under the Biden administration? Any opportunities for more information sharing?
I can answer this, that a lot of, I've received in conversations feedback from CBP that the response is always kind of, we can't disclose it because it's a law enforcement investigation. So I don't see, at least with certain levels of CBP that we've engaged with, I don't see a receptiveness to being open. I think that there would have to be kind of a change for that to happen. Not saying people would change, but just like a change maybe in, maybe the Biden administration could, use their influence to do that. But right now, I don't think that there is any, I haven't sensed any receptiveness to being open about sharing information. But I also want to highlight kind of what Charity alluded to earlier, that some of this information petitioners may request not be shared for reasons of protecting the information that's in the petition and possibly workers.
Anyone else on the forecast for the new administration on the Tariff Act and impact on how petitions will be assessed? Okay, moving to the next question. On the issue of transshipment, so you know that, as everyone knows, withhold release orders stop goods at US borders, but there is always the risk of importers or foreign producers simply re-exporting the goods to another market. So how do you handle this, and what are the long-term solutions to try and track all these potential transshipments? Are there more coordination? Does it require more coordination? Are there ongoing efforts? Any thoughts on this?
This is a big issue, and it's a really good thing to identify. Certainly, like in the Xinjiang cotton case, it is sort of assumed that there's probably going to be now a big flow of cotton into and these other products that have been banned into other countries, and then they will come into the United States afterwards. And with cocoa, a significant amount of processing is happening in Europe. So it's going to be going out of West Africa to Europe to be processed and then comes back in from Europe. So how is that being traced? I think this kind of gets back to the transparency issue. And this is data that companies have, and it's their choice to release it or not. We certainly need to campaign and put pressure on companies to provide more transparency. But this is just, I think that, the other option is maybe thinking about ways that we can bring civil suits against companies to get them in a situation of discovery where they have to be producing information based on discovery requests. That's not anyone's preference because it's expensive and difficult and time consuming and limited in terms of the data that you can get. But short of some kind of formal legal discovery mechanisms, it's not clear how we're going to be able to trace that. I think that CBP might have a few tools in their toolbox that that the broader community may not have. And, but beyond that, I think it's just a major problem that we need to figure out how to address. Maybe other panelists have ideas.
I can add my 2 cents, which is I think it's promising to hear, for example, I believe the EU is now considering having like a Tariff Act as well for its borders. And, even in the seafood context, there have been some conversations among NGOs about getting Japan to potentially have a Tariff Act for seafood imports, because it is now committed to having a seafood import monitoring program. So kind of closing the markets, the major markets for forced labor produced goods beyond the US, I think that will help a lot. Yeah.
I think there are 2 sides. One is that, ultimately, a lot of transshipment is essentially fraud and trade-based money laundering, and we aren't really calling it what it is. And so that then gives it the status of a kind of business currently a sort of business ethics problem rather than a criminal matter. And I think without giving it its formal, I think a more sort of I think honest status, then it's allowed to slip into non-disclosure and a kind of murkiness of, well, we just don't know. That said, you can use, if you don't already, tools like Panjiva and Enigma. There are various other open source Intel tools that give you a lot of information about, whether it's basic bills of lading or whether it's invoicing and so forth. You can pick up a lot of that to create your typologies. And but the problem is that without raising this thing to a kind of more criminal status, then a lot of countries, places that we've been talking about, don't feel any need to disclose or require the disclosure of bills of lading in the same way of shipping documents. And so you have this very unhealthy situation where, what is essentially taking place, I think many jurisdictions would be considered to be a criminal act, but we're globally kind of light on that in many jurisdictions. And because it's light, therefore there's no requirement to disclose. And so, if you take the other side of this, if you look at the flow of money going in the opposite direction to the flow of goods, there's, a lot of work to be done, but there's a lot more disclosure that you can find out about the flow of goods and a lot more legal tools to force that disclosure. But currently, with the flow of money is a lot more easier to track than the flow of goods, because simply the obligations to disclose and to record are very weak, because we only have an ethical framework and not under a criminal one.
Thank you, Duncan. And this is a point I think I made in my introduction, but just want to reiterate that under the US-Mexico-Canada trade agreement, Canada and Mexico are required to implement a tariff act like prohibition. To my knowledge, Canada has already done so, and they have amended their customs tariff to prohibit goods made with forced labor, much like the US Tariff Act. So that's definitely a bold move. And if US, Mexico, and Canada block goods and act as a continental shield against forced labor, that could create quite an impact and disrupt in supply chains. The next question. It is great to hear that CBP is considering WROs at the fleet or processor level instead of a single vessel. I think there's also a gap in as much as suppliers are the ones that really suffer a penalty under the Tariff Act. What about the retailers or buyers that buy from the offending suppliers? They should have some culpability under the law as well.
I can take that one. I mean, we wholeheartedly believe there needs to be more prosecutions of U.S. companies that are profiting from forced labor overseas. And I think I think having those prosecutions, just like with the WROs, initially there was only one. Once we started getting 2, 3, 4, and now there's going to be more coming, then that sends a strong signal to both U.S. companies and to overseas producers that this is not a one-off situation, and it's going to be a recurring risk, and that's important that they address that. And I think the same with prosecutions of companies that are aiding and abetting or not only profiting from forced labor overseas. That has to happen on a regular basis for there to be effective deterrence. Yeah.
Thanks, Andy. The next question is, do you feel that if any NGO has evidence of forced labor, is there an ethical duty to report it to CBP under the Tariff Act of goods coming into the United States?
Esmeralda, where are you going to go? Go ahead.
I mean, I think that I wouldn't say that there's an ethical duty because it does require a certain level of evidence and being able to obtain that evidence and submit it and having the capacity in house. So yeah, I wouldn't think there's an ethical duty to do that.
Yeah, I would say that, absolutely not, because, as we've been saying, this is like this tool is not totally fit for purpose. And so it's kind of a risky, touchy business to make the decision to use this tool in a particular situation. And so just because there is forced labor that we have identified, this might be a terrible way to address it, right? It could be very harmful to the forced laborers or other affected communities. So I think that it really needs to be a part of a broader strategy and a broader campaign to even consider using it. So I would say there's definitely not an ethical obligation, and there might be an ethical obligation not to, unless a bunch of other circumstances are satisfied.
Any quick thoughts, Duncan?
I mean, I think before you even think about doing it, as both Charity and Esmeralda said, that, I've heard that there are a lot of people that do complain. They write emails in saying, I've heard there's forced labor in this, and then there's nothing else. There is no evidence. There's no risk, because a lot of people complain and write in, give them a sad story, and then that's the end of it. And I think that's just clogging up the system with, poorly prepared complaints. So I think ethical obligation or duty or responsibility or not is, don't just write in with stuff, because we do need more complaints and more NGOs to make more complaints. As Andy said, it just needs more activity to make it work better, and for everyone to sort of have lessons learned. But it doesn't need poorly prepared petitions. And so, from my experience, don't just write in with a paragraph saying, I saw this industry as a complete nightmare, do your worst kind of thing. I don't think that's going to help either.
Thanks, Duncan. The next question, and I'm going to run through the next couple of questions quickly because we are in the last 5 minutes, the final stretch. So the next question, which is interesting, is do you anticipate that companies may actually sue CBP or the US government for this kind of enforcement? And to my knowledge, I know this might have not yet happened, but do you anticipate that it will with increasing enforcement?
I can, take a stab at that. And I think with my understanding of CBP's approach, I find that to be unlikely because they're very risk averse. They take action on cases that they feel are strong and they're strong evidence. And in many cases, they go and obtain evidence beyond what they need for reasonable suspicion, which is a very low burden of proof. So for WROs, I don't think that's likely to happen just based on their kind of more conservative approach to these cases. But if we start seeing more findings, then I think that they're gonna probably deliberate more internally, making sure that they have a strong case before they go public with that. Yeah.
I know that a couple of hired US lawyers to at least mount a defense, and I'm sure those US lawyers will have said, what about suing these guys? And certainly in our conversations, the issue of, well, what if there is a suit? How is discovery going to work? What will you be required to? That's all often discussed, certainly from my experience. So it's certainly something they've contemplated, but I would probably go with Andy that it seems unlikely, but it's not impossible. A suit, there's some lawyer somewhere who's like, yeah, what the hell? Here's a letter. So you never know.
Thanks, Duncan. The next question is, have any of you used the threat of a CBP action or a withhold release order to gain commitments from corporations? Okay.
That's a great idea, actually. Thank you for raising that. No, I mean, seriously, like we talk about CBP WROs, obviously, because that's already on the company's minds, whether it's the buyers or it's the producers or the traders. That's something that it is a significant risk that they're concerned about. So that in combination with other, I would not call it a threat, but other tactics, I think have proven to at least push the needle a little bit and move companies in the right direction.
Thanks, Andy. Okay, I'm going to move to the next question, which is again important for the safety and security of the petitioning organization and workers. Can companies or other actors successfully get sensitive information from civil society investigations or this process through FOIA requests to CBP?
So I understand that they can, and that's something, I don't know, when we signed our MOU with CBP, that was something that was heavily discussed about what can a FOIA request elicit. And so, for instance, in practice, without being able to think through exactly what that risk might be, because it hasn't really happened, obviously everything anonymized, no names, you're just going to have to build a good information risk management tool, which that's what we did certainly, to make sure that you're not forwarding emails with someone's name on the top of it, that if you are providing anonymous expert witness, that it is anonymous, that you've pulled out the name in the Word document of the person who created it. You've got to build all that into your efforts to make sure that it only goes as far as liberty shared, which is obviously there's always going to be things, but yeah, I think that's something that we considered and we spent a long time talking about. But as nobody has any kind of shape to what that might look like, you're just trying to take every precaution you can.
Charity, you want to add?
I would just add that this is a real problem, right? I think that we're getting back to whoever's question it was about did someone even ask this about verifying the information that CBP receives? If civil society provides information, how does CBP verify it? Not only do we not have information about that, but the information that we provide to them, because we don't have any clear sort of guidance on what kind of firewall might exist and how private, how protected we can keep this information, we're giving them information that in a lot of cases isn't that verifiable, to be honest. Like, it'd be very difficult for them to follow up on some of it because of how anonymized it is. And so I think that's an issue that I'm not exactly sure how we're going to address, but would probably make things easier on CBP and civil society, and frankly, the companies, because if they were able to verify information, that would be helpful.
Yeah, I was just going to say, I think it's smart to assume that if you share information with the US government, that it could be FOIA'd and act accordingly.
Thanks, Esmeralda. I think we're almost, we've hit the 4:30 mark. So unfortunately, all good things must come to an end, as is this webinar. So I'm afraid we'll have to stop the Q&A session. But if you do have any further questions, please send them to us and I will direct them to the panelists. So thank you all for your wonderful presentations. Thank you to all the attendees for joining us today. I hope you've been enriched by the information and perspectives of our panelists. Just please remember there is a survey that might pop up right after this webinar ends. So please know what topics you're interested to hear from us in the future and who you would like us to feature. So thank you and have a nice day.
Thank you.
Thanks.
Thanks.
Bye.
Bye.